welcome to question 69 of the Secunda Secundae. The topic this week is sins committed against justice by the defendant. And I'm Dr. Thibault. This question is in the context of a bigger area. So we're looking at the theory of justice. We're looking at sins against commutative justice, vices of commutative justice. Then we were looking at deeds, vices of deeds against commutative justice, which were murder and maiming, hitting people, imprisoning people, stealing their things. And now we're doing words against commutative justice, which has been this area of trial. So the trial section we're in. So we've already covered an unjust judge, an unjust accuser, and now we're doing an unjust defendant in this time. The first question is it a mortal sin in denying the truth? Can you deny the truth, which would lead one to condemnation? So if you tell the truth, you are condemned to death, or life in prison, or torture, or whatever it would have been in the Middle Ages, depending on the crime. Can you deny the accusations without accruing a mortal sin? That's the question. This is a tough one, but whoever acts against the due order of justice sins mortally. So the question is really ultimately, is the lie in order never in promotion of the truth. If you lie in order to avoid the truth, that a mortal sin? Well, yes, it is. You can never lie. That's the line that's repeatedly expressed here. You see that in almost every question of this, every article of question 69, that lying is against the truth, and therefore you cannot lie. Can you be silent? Depends. If the judge is asking you a question that is a legitimate question that you should answer, then you can't remain silent. It's a just question. If it's a question that the judge should not be asking, then you can remain silent. So I have to admit I'm a little bit uneducated on some of the medieval legal system that he's referring to. Perhaps I'll get more into that, but maybe I shouldn't even be making this video, but I'm not sure I know enough about it, because in the present day we have a law, plead the fifth, as we say, that you don't have to self-incriminate. So if you you never have to, under the current system, self-incriminate yourself. So in that regard, you could remain silent. So I think that might be the same that you're talking about in the Middle Ages. If you have a right to remain silent, you have a right to not self-incriminate. If the judge were to ask you a question to self-incriminate yourself, you have a right to refuse to answer, because you have a right to avoid self-incrimination. It'd be interesting if that law goes back all the way to the Middle Ages. Perhaps it does. I imagine in this, at the very least, there are some things which, under the medieval legal system, you are not required to answer, probably because of some type of protections against self-incrimination. So in those cases, you don't have to answer. But in some situations, he says that you do have to make an answer, then you ought to. But it is never lawful to lie. In terms of the unmasking of the truth, it's kind of interesting. Still in Article 1, when a man is examined by the judge according to the order of justice, he does not lay bare his own guilt, but his guilt is unmasked by another, since the obligation of answering is imposed on him by one whom he is bound to obey. So this is kind of an issue of due process. The legal system doesn't require people to get up there and just admit guilt. It's up to the prosecution or the plaintiff to make a case and to ask questions and to present evidence and to do what they need to do in order to prove that you are guilty, to unmask the truth. It is not the obligation of the accused to get up there um, and spill their guts, to reveal everything. Um, um, can you then, in the unmasking process, uh, lie again? As this is quite repetitious, he says, "He who lies in court by denying his guilt acts both against the love of God, who is the just judge, and against the love of his neighbor, who is both the judge and also the accuser." Now, this is interesting because, as you might recall back from question 60, uh, was it just 68? You could see that if somebody were to accuse somebody of something, it was found that it was not true, then that person might have to face the penalty themselves. So if the penalty of this accusation, let's say it was murder, is death, then the accuser, if the accused is found to be not guilty, the accuser might be the one that faces the death penalty for the false accusation. So if you were to lie in the case, you might be actually committing the accuser to death. And now, if you actually had performed that crime, now you should be the one to receive the death penalty. Instead, the accuser is the one that's going to receive the death penalty. So there are real consequences here to lying, very serious consequences. Now, I have to admit that there's some part of this that I'm still somewhat uncomfortable with, where if St. Thomas is talking to potentially accused people, defendants, um, this idea that the idea that he laid out is that punishment is the medicine for the vice. So if somebody has committed a crime, the point of punishment in justice is to protect the public and to serve as some type of penance for the sin that has been committed. So if a person were um, to say, yes, I know I did it, you think that they should morally uh, admit to their sin. If you are a murderer, you should admit to it. If there's a good reason why you've done it, then come up with a defense of why it was self-defense or what the issue was. If not, if you have no defense whatsoever, perhaps in the modern day, something like drunk driving or something like that, well, then seems like the most ethical thing to do would be to admit it. um, Not that you have to um, throw yourself under the bus, but if you want to take real responsibility for your actions and to work on forgiveness and worry about your eternal soul, then perhaps coming to truth and just saying it outright would be the most appropriate way. Later on, St. Thomas talks about the sin of irony, which is not telling the whole truth. So, irony is already seen as a sin. So, in order to not withhold information seems also to be a bit of irony, which is at least a venial sin. But this isn't an area which St. Thomas has brought up at this point. He does raise this idea that you don't have to self-incriminate, which is interesting. I understand it from a legal perspective. I'm not sure I fully understand it from a theological or an ethical perspective. Um, can you lie or use false statements to defend yourself? Calumny is what he's talking about. And he says it is one thing to withhold the truth, it is another to utter falsehood. If the guilty is already, if the guilt is already apparent, it's very obvious that you're going to be found guilty. You don't have to further that by further self-incriminating yourself. Justice will be done by the truth. You don't need to make it any worse for yourself, is his point. Um, and it is lawful for the accused to defend himself by withholding the truth if he is not bound uh, to avow that information. So, as we've already kind of said this before, again, repetitive to the first article, but you don't have to reveal more than you're required to reveal, but you cannot lie. So, can the accused appeal? Interesting. There's two motives to an appeal, he points out. One is if one has been found guilty unjustly, innocent, you shouldn't be found guilty, then appeal. It's lawful to appeal if you've been found incorrectly guilty. If the judge has acted against you unfairly, because as you know from an American legal system, the appeal isn't that you don't like the verdict. The appeal is that there has been a procedural problem. Uh, Witnesses who shouldn't have been allowed to testify were testify. Evidence that shouldn't have been put into the record were put into the record. It's some type of due process issue that the judge has made a mistake. So if you're saying the judge has made a mistake, then appeal. Uh, if you know you've done it and everything was done correctly, um, then if your only attempt to appeal is to delay the sentence, then he said that's unlawful. If your whole point is to just avoid the inevitable uh, uh, sentence, then and you did it, then you should accept the verdict and then work on your salvation, not delay it and hold up the court system. Um, and he says uh, if you were to appeal and you were guilty and you knew you were guilty and there was no procedural errors, you should be further punished for it because um, it's an unjust appeal. So you had an unjust action, now you have an unjust appeal. There's now another level of injustice. And very interestingly, he says the appeal must be made within 10 days, which seems like a very procedural thing for St. Thomas to be talking about. But his reasoning is that you don't want, if a person thinks that justice has been gained for them, you don't want 2 years later, all of a sudden, now there's an appeal, or 3 months later, there's an appeal, that there needs to be some sense of closure in this. Um, After the verdict has been made, if you want to appeal it, get a good legal advice, get a good lawyer, see if you have a case. If you do, appeal it. If not, then it's over. So there's a time limit on that. Okay, if a person is condemned to death, this is the last of the articles. Um, uh, can the person try to escape? Can a person avoid the punishment or try to avoid the punishment if they have been condemned to death or condemned in any way, I suppose? Um, and the answer is two ways again, and this is again quite repetitive, or at least maybe I should say repetitive, quite consistent with what he has been saying throughout this question 69. Um, and if one has been justly condemned, well, then you must accept the sentence. That's it. Justice has been served. In some sense, the judge acts for a higher authority. Therefore, you should accept that and work on your salvation. If you have been unjustly condemned, there has been uh, evasion. There's been collusion. There's been a setup that this is an unfair trial. You have been unfairly condemned. Um, uh, then it is possible to resist the wicked. And he says you can resist a robber, somebody who's trying to take your property unlawfully. You can also resist them as you would a robber against the wicked princes, he says. Now, it doesn't really address the idea of what if you were found guilty and it's because you just didn't have a very good defense. You didn't have an alibi. There's no collusion. There's no conspiracy against you. It's just unfair. It's just you didn't have a very good case. um, well, St. Thomas doesn't really consider that. He tends to think that a judge in justice is to prove you're found innocent until proven guilty. That you have to prove that the person is guilty. If you have been proved guilty, then you're probably guilty, um, unless there's been a corruption of justice. That's the only time when it wouldn't be. Um, uh, and it says if you've been unjustly convicted, then you're not bound to do anything in order to resist your own death. It doesn't say anything like you can kill somebody else in order to avoid it, or to strike anyone else to avoid it. But you certainly don't have to stay still. If you could break out of the prison, St. Paul had done, you're welcome to do it. That's possible. As they're moving you to the execution, uh, if you can escape, escape. If you can, as long as it doesn't create civil unrest in such a way that will maybe it could create fighting in the streets and other people would die. If it doesn't create that type of scandal, and you can escape, then escape. Um, he does say even too under this one that even if you were justly condemned to death, if let's say the sentence were that you were to starve to death, which sounds like an awful uh, punishment, starvation. If somebody were to bring you food, you can still eat it without sinning. Uh, you don't have to actively participate in your own execution. If you have been justly condemned, then you should not resist it, but you don't have to actively participate in it. And lastly, he says that judges act under the authority of a king or prince, which is a sign that it is properly ordered. And he says that in Article 3. Well, it's more applicable here as part of this, in terms of lawfully defending yourself. Uh, the judge is not acting on your behalf, he's acting on behalf of the prince, which is why I think he says in number 2, under this part, unjustly, it is lawful to resist a wicked prince. Well, if the judge is under the authority of the prince, then you can resist the prince and the judge simultaneously because they're in the same group. So in conclusion, you can remain silent on matters, but you cannot lie. You can appeal to escape judgment if you are unjustly accused, and one can attempt to escape from condemnation if unjustly convicted. That is St. Thomas's topic on the unjust defendant. See you next time.